Hi, Amy Pittman, and I'm going to start doing a series on our basics, the basic documents that we include in an estate plan. So today I'm going to talk about the living will. We have a lot of questions about a living will, and sometimes there's misunderstandings between a living will versus a DNR. So first let me explain, we do not do DNRs. So lawyers are not having you sign a DNR. A DNR is a do not resuscitate order. Now that is something you have to get from your primary physician, and they sign it with you if they believe that that's something you need to have, which means there's no CPR given to you. That is on a bright yellow form in the state of Florida. What we will prepare and what you will see a lot of hospitals will have available to you for their provider is a living will that says in the event that you are terminal or in a vegetative state or in an end-stage condition. So I'm one of those three, I'm not all three. And there's no chance of recovery. Two doctors have to agree that I meet one of those criteria before my healthcare surrogate can enforce my living will. So it is up to my healthcare surrogate to enforce the living will, not the doctor, not the hospital. So if my spouse is my healthcare surrogate and Josh is not, ready to pull the plug, which is what you hear a lot of people say, he doesn't have to. He can follow what he thinks is best for me. Maybe he wants me to live forever, I don't know. But that living will is just me stating my wishes. My healthcare surrogate, which we're going to talk about in another video, is the one who's going to enforce a living will. It is the one that you hear doctors ask about every time we go into the hospital, but it's just putting out those wishes that I do not want to be artificially prolonged if I'm in a vegetative state or terminal or in an end-stage condition and there's no chance of recovery. And usually in Florida, it's only 1 or 2 pages long, and it allows that surrogate to make that decision for you. Now, I will say, in my experience, we don't have too many clients dying from a living will because my healthcare surrogate can still make an end-of-life decision even if I'm not within the terms of a living will. And even if I don't have a living will, maybe I never had one signed, my healthcare surrogate can still make an end-of-life decision based on those terms as well. So it's just really trying to make you think about it ahead of time, so hopefully the people you name have some direction on what you would want. Now, we always are telling our clients, if your client's a Pittman Law Office, you need to communicate your medical wishes, especially if you have a diagnosis or some really clear views on end of life and what you would want. Or maybe I'm just incapacitated and not able to make these decisions of where do I want to go. A lot of our clients in the villages end up being moved back to where one of their kids are, and maybe you want to make sure you go to a certain kid, or maybe not a kid at all. So definitely talk to the people that you named. And I know, like most of you know, that I have a large family. So in my case, if I have, my parents have 7 kids, they're not just going to tell one of us what they want. They're going to make sure they tell all of us so that we are supporting the sister who is named as the healthcare surrogate. We don't want to create conflict or a lot of dispute going on in this type of situation. So make sure that you tell people who you've named so they're already prepared for that, so there's not any fighting within the family. All right, hope you enjoyed that. Hopefully it was some educational information, and you can always find more information on our website as well. Have a good one.